Something extraordinary is happening inside a London courtroom right now. And what most people are missing is that this is not really about Prince Harry or celebrity grievance or even tabloid excess in the narrow sense, because this isn't just another lawsuit about hurt feelings or invasive headlines. It's actually a stress test of whether Britain ever truly reckoned with the machinery of surveillance journalism it pretended to dismantle. And what we're watching unfold is the collision between an institution that learned to survive scandal and a claimant who is refusing to let time bury the evidence. So stay with me, because what emerges from this case could quietly redraw the boundaries between press freedom and systemic abuse. And the scene itself matters because as phones light up outside the High Court and aides whisper in corridors that feel less like halls of justice and more like pressure chambers, the atmosphere is not theatrical but brittle, like ice that has been stepped on once too often, because everyone involved understands that this case is reopening chapter many powerful actors believed was already closed. And that's why this matters, because while the surface story is about articles published between 2004 and 2010 and a long-ended relationship with Chelsy Davy, the deeper story is about how information was extracted, who normalized the methods, and why accountability keeps arriving decades late, if it arrives at all. Because Prince Harry isn't just alleging that journalists knew too much. He's alleging that they knew it because they crossed lines that were supposed to be bright and uncrossable by paying private investigators, by bribing intermediaries, and by treating personal data as a commodity rather than a boundary. And what makes this unsettling is not the accusation itself, but the familiarity of it. Because Britain has been here before, swearing after phone hacking scandals that the worst abuses were exposed, corrected, and consigned to history. Short sentence. That promise didn't hold. And because the defendant, Associated Newspapers, insists this was all lawful cultivation of sources. What we're really watching is a battle over definitions, over whether intimacy implies illegality, and over whether patterns that look systematic can be dismissed as coincidence when time has blurred memories and scattered paper trails and behind closed doors. This is where institutional self-preservation kicks in, because admitting unlawful methods would not just damage one publisher, it would implicate an entire era of tabloid practice that thrived on proximity to power, access to databases, and the quiet assumption that consequences could be outweighed. And here's what few realize. Because while Harry walks into court without comment, refusing the performative outrage the media expects, his silence is strategic, because the real argument is being made through invoices, emails, and articles so detailed they read less like reporting and more like surveillance logs, because this isn't about whether the press should be adversarial, it's about whether adversarial became predatory and whether the safeguards that were supposed to stop that were ever enforced. And this is where the framing breaks down. Not because Harry is famous, but because he is persistent. This case threatens to expose how easily unlawful behavior was laundered through the language of journalism. And as the judge signals that facts, not feelings, will decide this case, the subtext is unmistakable, because facts have a way of surviving longer than reputations. And this is where the real story begins. Because once you start asking how those facts were obtained, you cannot stop at one claimant, one newspaper, or one decade. And this is where the significance deepens, because once you move past the optics of a prince suing a newspaper and start laying the evidence side by side, a much older and more troubling pattern comes into focus. One that stretches back through Britain's tabloid culture and reveals how normalized misconduct disguises itself as routine journalism. And because inside that courtroom, Harry's lawyer, David Sherborne, didn't just wave at abstract wrongdoing, but placed specific articles, dates, and invoices on the record. What's being argued is not a vibe or a grievance, but a method, repeated often enough to look less like rogue behavior and more like a system. And when the court hears about articles from 2004 to 2010 describing private routines, travel details, and relationship plans with a precision that would require access to airline manifests or confidential briefings, the question stops being whether journalists had sources and becomes whether those sources were lawful at all. Short sentence. That distinction matters, and because Associated Newspapers insists this information came from acquaintances in cultivated contexts, the defense is relying on a familiar psychological move, reframing improbability as coincidence and repetition as professionalism. And what makes this dangerous is that it mirrors the same logic deployed during the phone hacking era, when editors claimed extraordinary access was simply the result of journalistic hustle rather than systemic illegality. And here's what most people forget. Because after the Leveson inquiry promised reform, much of the industry quietly returned to business as usual, protected by time, complexity, and public fatigue. And that's why this matters. Because the emails and invoices shown to the court referencing payments to private investigators and contacts inside airlines and public institutions don't exist in isolation. They echo patterns already documented in earlier scandals. And while the court proceedings continue in their careful, procedural rhythm, something darker and more consequential is building beneath the surface, because this case is no longer confined to what happened to one individual or even to a cluster of claimants. It's about what happens when an entire information ecosystem begins to bend under the weight of its own unresolved contradictions. And because the defense insists that lawful journalism can look invasive without being illegal, what they're really asking the court to accept is a version of reality in which proximity replaces proof and repetition replaces accountability. Short sentence. That's a dangerous trade. And this is where the facade cracks, because when institutions argue that intimate knowledge is simply the product of long cultivated sources, they are also implicitly admitting that access itself has become a form of power, one that operates largely outside public scrutiny. And what's truly alarming is that this logic doesn't stop at tabloids, because once you normalize the idea that information can be quietly extracted through informal networks, you begin eroding the distinction between reporting and surveillance. And that's why this matters, because in any previous era, evidence suggesting payments to private investigators and insiders within airlines or public bodies would have triggered immediate institutional panic. Yet here it is being framed as historical noise, as something too old to interrogate seriously, and because normalization is the most effective anesthetic in politics and media alike, the real risk is not that wrongdoing occurred, but that it is now being treated as inevitable. Short sentence, it shouldn't be. And while Associated Newspapers argues that time has scattered documents and memories, that very absence becomes part of the story, because systems that rely on opacity always benefit from delay. And this is where power dynamics come into sharp relief, because publishers retain archives, lawyers, and institutional memory, while individual subjects are left with impressions, distress, and fragments. And behind the scenes, editors across Fleet Street are watching closely, not because they fear losing a case, but because they fear losing a norm, the unspoken understanding that aggressive reporting will be forgiven if it is profitable enough and distant enough in time. And this isn't about a chilling effect on journalism. It's about a revealing effect, because when courts begin asking not just what was published, but how it was obtained, the entire supply chain of information comes under stress. And the deeper problem is that democratic societies depend on a press that exposes power, not one that quietly mimics it, using leverage, inducement, and asymmetry to extract private life as content. Short sentence. That inversion matters. And as Prince Harry prepares to testify, his credibility will be scrutinized not just as a witness, but as a symbol, because if his testimony is reduced to emotion, while documentary evidence is dismissed as circumstantial, the message will be clear that systemic issues are safest when individualized. And this is where the escalation becomes undeniable, because what looked solid, the post-Leveson settlement between press freedom and restraint, now appears brittle, held together by assumptions rather than enforcement. And the cost of this will not be measured in damages or headlines, but in public trust. Because once audiences accept that invasive practices are simply the price of information, the line between scrutiny and exploitation collapses. And this is no longer about tabloid excess. It's about whether democratic institutions can function when one of their central watchdogs operates with incentives that reward boundary erosion. And this is where the story tilts forward, because whatever the verdict, the precedent being set is about how much the past is allowed to matter when the present would rather move on. And this is where the story ultimately lands. Because when you step back from the testimony and the invoices and the procedural sparring, what we are witnessing is not a celebrity reckoning, but a democratic one, a moment where a society has to decide whether it is comfortable letting its past remain conveniently unresolved. And because this case forces the court to look backward rather than politely forward, it exposes how often accountability is treated as a mood rather than a duty. Short sentence. That's the risk. And this isn't about whether newspapers should be aggressive. It's about whether aggression without limits quietly mutates into entitlement, where private lives become raw material and legality becomes a technicality to be argued years later. And what makes this moment historically significant is that it arrives after repeated assurances that reform had already happened, that lessons were learned, and that the worst behaviors belong to another era. And that's why this matters, because history tells us that democracies don't usually collapse from a single scandal. They erode when patterns are acknowledged but never fully confronted. And behind the scenes, the real audience for this case is not the public, but the institutions themselves, watching to see whether delay still works, whether complexity still protects, and whether power can still outlast scrutiny. Short sentence, sometimes it does, and sometimes it doesn't. And the question is no longer whether Prince Harry can prove illegality. It's whether societies are willing to accept that truth often arrives late and still demands response. And once you see this, you can't unsee it. Because what at stake is not a verdict but a signal about whether democratic systems retain the capacity to self-correct. And that leaves us at a choice point, because attention itself becomes a civic act, and indifference becomes permission. And this is where responsibility shifts outward, because what we tolerate quietly becomes what we normalize publicly, and what we normalize eventually defines us.